Hey everybody. Um, as you're coming in, let me know if you can hear me okay. It's hot, so I have a lot of fans on right now. But I hope you guys are having a good day so far. I wanted to do just a little bit of a test stream, um, and kind of see if anyone wants to keep me company while I'm studying for the bar. Um, I keep, I mean, I just keep getting distracted. And I think it would also be really helpful for people to see like how the law works and how lawyers prepare. And I know that you don't have a lot of opportunity to ask lawyers, these types of questions. And also just might be fun to chat. So as you're coming in, let me know if you're interested in law school or how you found my channel. Um, Today, what I'm working on is going over my torts outline. And when I say outline, that's basically just like a study guide of one topic of law. And this topic is called torts. And if you don't know what torts are, it's basically um, actions that cause harm. Um, when I say that, I mean like they're things that you can sue for. Sorry. So when I say that, like torts are everything from like negligence or medical malpractice or defamation. Um, yeah, and it's a really vast topic. I think the study guide that I have has about like 80 pages. I have 20 more to go through. I'm really trying to get through them so I can move on to doing the next topic, which is constitutional law. So if that sounds interesting, then you'll definitely want to stick around for that. That one I probably will have to stream because it's just so boring. It's basically So today, like I said, I'm working on my torts outline for today. And as you're coming in, like I said, feel free to let me know if you have any law school questions, questions about preparing for the bar. Okay, I'm stalling. I'm totally stalling to try not to start studying. So let me go ahead and start. And like I said, feel free to ask any questions in the chat. This is going to be really chill. I'm just going to talk out loud and maybe you'll learn something. And if you want to ask me any questions, feel free to. And I am also an LSAT tutor. So if you have questions just about like law school admissions or how that works, you can ask those too in the chat. Okay, let me figure out what page I am on. I left off on page 61. My study guide for this topic has 97 pages, so that's fun. Okay. Um, let's see, what are we talking about on page 61? Okay. So this is actually going to probably be helpful for me because explaining things out loud is a great way to learn. And especially for the bar exam, um, you don't have it's not open book. You don't have any study guides. Everything has to come from your brain anyway. So the more you practice translating what you're reading into your own words, the easier to come to you on exam day. So maybe you'll get some test prep tips from here too. Um, all my test prep tutoring definitely helped me with the MPRE. Um, And if you don't know what the MPRE is, it's a test that tests on like ethics for lawyers, and you have to take that before you take the bar. Okay, let me stop stalling. So let me arrange my screens here. What I have is I have one, oh shoot. I have one screen that is my outline that has all the law that I need to learn. And then my other screen is going to be my notes that I'm going to take. Okay. So what are we learning about today? Let's see. Today is about when you have multiple people who are liable or responsible for something in a lawsuit. Okay. Sorry, I'm trying to figure out the best way to get this arranged. And if you are just tuning in, feel free to ask me any questions in the chat. I'm going to get started here. I'm totally just stalling because bar prep is very, very boring. But I think I'm figuring out a good layout. I'm just testing this out and seeing, maybe it makes it a little less painful to do bar prep. Okay, I think this is fine. Okay. So what do you do when you have multiple people responsible for a tort? Okay, that is called joint and several liability. And if you don't know what liability means responsibility, basically. If you're liable for something, you're responsible for it. And this is all civil court. So none of this is in criminal court. All of this is in civil court. And civil court is where you go when you basically want money. There's other things you can get to, but the most common thing we think of in civil court is suing for money. And if you are just joining, feel free to drop in the chat how you found me and if you have any questions. Okay, so this is called joint and several liability. And under the doctrine of joint and several liability, two or more tortfeasors found liable for a single indivisible harm to the plaintiff is subject to liability for the plaintiff for the entire harm. Okay, so what they are saying joint and several liability is, it means that if there are more than one people responsible for the act, they each are responsible for their portion of the harm and the entire harm. So what that means is that and this is, if you'll notice that I'm going to back up and like correct things as I'm reading, because as I'm reading, I'm like processing. So this is for injuries where you can't definitively say who caused how much. So for example, like maybe you could say someone caused 20% of this damage and 30% of this damage, but like what happens when you don't know who caused how much of it? Then one of the ways that we keep people responsible is by just making each person responsible for the whole amount. So basically they're saying when you have joint and several liability, there's three things that can happen, meaning there's three ways that the plaintiff can get what they're owed. Three ways to collect. When I say collect, I mean three ways to collect the money. And I'm talking very basic terms here. Obviously, like lawsuits get really complicated, but when you're starting to just learn about the law, it's easiest to keep it like as simple as possible. So there's 3 ways to collect the money when there's multiple people involved. You can get the entire amount from one defendant. You can get the entire amount from another defendant, or you can get pieces from different defendants. Okay, so now I'm gonna like look away from my screen and I'm gonna say that out loud just to make sure like I got that. So when you have multiple people responsible for the tort and it's an indivisible injury, meaning you can't easily portion the damages in ratio to liability, you want to use joint and several liability. Joint and several liability means that the plaintiff has 3 ways of collecting their judgment. They can get it from one defendant, all of it from one defendant. They can get all of it from another defendant, or they can have the defendants each give them amounts that add up to the whole. Okay, cool. Think I got it. If you're in the chat, feel free to say hi and let me know. I mean, I don't know how this is going. Maybe this might help you sleep if you're trying to take a nap. I'm not sure. But I think it's working for me. Okay. And then, okay. So now I have some examples of when this happens. Okay, I'm not going to write down these examples because they all just are examples of multiple people being responsible. And that's one thing that you learn in law school, and it's just smart for like studying, is like knowing what's important to retain and what's not. And like for bar prep, there's so much that you at least need to make sure you have the basics down. So I don't need to remember for like right now, and this is just how my brain works. I don't need to remember like 5 specific examples of when joint and several liability applies if I can internalize like it applies when there's multiple defendants responsible and it's an indivisible injury. And importantly, of course, I say all of this, and then the last note in my study guide says most jurisdictions have either eliminated it or limited how it can be used. So this is another example of why being like in law school and learning the law is so annoying. I mean, it's still important for us to know, but it's an annoying note to just like learn that and then be told like you're probably never going to use it. But gotta write that note here. Most JX eliminated. And JX for me stands for jurisdiction. It's just, and jurisdiction is just like the area that is a court controls. And it's just such a long word that I shorten it to JX. Okay. So next up is contribution. So contribution, and this is also me speaking because we took most of sorry, I'm starting and stopping my sentences. Most of these topics that we're learning for bar prep, we learned in law school, but a lot of them we haven't seen since like the first year. And the first year is so overwhelming, like it's impossible to retain everything. So a lot gets lost if you're not using it in your second and third years. So anyway, this is kind of just like me remembering back on my torts class, but you'd be surprised how much you can remember from just one class. But anyway, the next part we're going to talk is about contribution. And this means contribution. This means when there's multiple defendants and each pay their part, basically. So this happens, again, if 2 or more tortfeasors, okay, so just 2 or more people are liable for the same tort, and one tortfeasor has paid more than their fair share. Okay. So one thing that has to happen is one defendant paid more than their fair share. And that means paid to the plaintiff. Okay, so then if they paid more than their fair share, that person can sue another responsible person for contribution. Can sue another defendant for contribution. Okay. All right. Okay, that makes sense. And then it says seeking contribution, you must prove that, oh my God, you must prove they would have been liable to at least that amount. Okay, so you have to prove that defendant's responsibility for that amount. At least that amount. Okay, so now they're talking about how do you figure out what fair shares are. So to determine fair shares, it says in most jurisdictions, it's determined by comparing how far each person departed from a standard of reasonable care. Okay. Fair share. So fair share is equal to, I mean, it's basically, let me think, in like simplest terms, how negligent that person was. But what it really means is how far they got from, how far away, how far, I don't like the way that the study guide phrases it. But I guess I'll just say how far from the standard of reasonable care were they? And you might be wondering, like, what does the standard of reasonable care mean? So in negligence cases, this is very general. There's lots of like caveats to this, but in general, the court, to determine whether you were negligent or not, they're going to think, would a reasonable person in those same circumstances, would they have done what you did? And that's called the standard of reasonable care. And so they're saying that the fair share for contribution, to how you determine each defendant's fair share for contribution is by looking at how far they deviated from what a reasonable person would do. Okay. But that also has a note here that says if it's an intentional tort, they may not seek contribution. So that's an important note. Contribution, not for. Okay. Yeah, I'll just say not for intentional. And when we think about intentional torts, that's different than negligence. Negligence is just like you didn't take as much care as you should have. Intentional torts is like you intended to cause damage. And those are things like assault and battery and like theft, things like that. Okay. All right. Okay. I feel good about contribution. All right. So now, okay, this helps with earlier. So earlier we were talking about joint and several liability. Now they're telling us what several liability means. So I've always been annoyed by joint and several liability because I feel like they don't, if they would just tell us what the joint meant and what the several meant, then I could put the two together. But like every book and every class that talks about it, like they never explain it that way. But anyway, so the joint part makes sense because this is when there's more than one person responsible. Um, the several part. So several liability is when you're only responsible for your fair share or your share of the responsibility. So let me just that. Okay. Um, several liability. That means you're only responsible for your share. Only responsible for your part. Well, what do I say? For your share. Yeah. Okay. Well, yeah. You can hear like the soon to be lawyer. I am not a lawyer now, obviously, but you can hear like I feel like my lawyer gears working because I'm like overthinking every single word that I'm typing. But that's probably good because that just means I'm like learning it better. Okay. Um, I forgot what I was doing. Tortfeasor. Okay. Now it says most jurisdictions restrict or reject joint and several and instead recognize pure several liability. See, like that makes no sense to me when why his study guide would jump around like that. Like why couldn't he have told me that at the beginning? But whatever. Um, this is why I also really want to just like write my own study guides because I've been a tutor for so long and I was a teacher and then I'm tutor for like 10 years. Um, yeah. So like sometimes when I see study things, I always come up with like my way that I would do it. And of course the way you say you would do it sounds better. Um, okay. Anyway, sorry, I need to write this. And this is used in um most jurisdictions. Okay, they call this pure several liability. That makes sense. So like several people are going to be liable because you're only liable for your part, not the whole amount. Um, and again, they say it's determined by how far from the standard of reasonable care. Got it. All right. Um, once the plaintiff has recovered, the plaintiff is then barred from further action. Yeah, I know. The plaintiff has not been wholly compensated. The modern rule release diminishes release. Okay, I'm not writing that. Indemnification. Um, okay. Indemnification. Sorry, I'm looking through these notes thinking, do I need to write this down? So I already know what indemnification is. And let me write down the word that I'm saying if because I don't know if you may not be familiar with it. Did I spell it right? Yes. So indemnification is when someone has to reimburse you for something. Um, so it's basically someone saying like, hey, if you get sued for this reason, we'll take care of it, the money we'll take care of the money for it. And whether that means like, the money for the judgment, the money for the lawyers, that's like all um to be decided. But it's saying like we'll cover the costs. Um okay, so they're talking about vicarious liability. Okay, I do need to write this down. Um so paying okay. So um happens in vicarious liability. And what that means is like when someone else is responsible for someone else's decisions. So think of like, a company's responsible maybe for what an employee did, or like um a manager might be responsible for what like their supervisee did or something like that. So they're telling us that this like reimbursement, I don't put reimbursement here. Um, the person who has discharged the liability is entitled to indemnity from the actual wrongdoer who is primarily oh gosh, I don't know what I'm reading. What? An employer who pays a judgment, the person who's discharged the liability is entitled to indemnity from the actual wrongdoer. Okay. Okay. So all of that was just to say indemnification happens in vicarious liability. So let's say like um that there's like some kind of maybe like if the employee did something and in their like employment contract they say that like if their actions cause a lawsuit they have to be responsible for the money. That's what this is talking about. It's saying like the like if you think about it, the supervisor, the company, the overseer wouldn't be responsible to pay. It would be the person who was below them or like that they controlled. Let me know if that makes sense in the chat or not, because also your guys' feedback will, like help me prepare for the bar too, because then I can like see how well I really understand it. Because if I can explain it clearly, that means that I probably understand it. If it's a little jumbled, then I probably need to think a little bit more about it. Okay. So blah blah blah. Other times indemnification happens. Um, prior significant difference. Strict. Okay. So it happens in vicarious liability. Can happen if one person is substantially like more at fault. And under strict product liability. And what strict means here, it means that no matter whether you meant it or not, you're responsible for it. So like there's some um like like speeding, like whether you meant to speed or not, if you like you're responsible for your ticket whether you meant it or not. Parking, if you if whether you meant to like overstay your time or not, um you're responsible for it. I'm not actually sure those were great examples. Yeah, but basically strict means whether you meant it or not, if it happens like you're responsible for it. Okay, anyway, they're saying under products liability, each supplier has a right of indemnification against all previous suppliers in a distribution. So strict product liability, each supplier can collect from previous suppliers in distribution chain. Why that matters, I can't really, I mean, it does make sense if like, so like if you put a product out, I actually don't know. I can't remember enough about strict products liability to actually explain that one, but I know it's coming up, so I'll relearn it then. Okay. Um, Indemnity and degree of blameworthiness is rejected in jurisdictions with comparative negligence, although indemnification is allowed when it's not based on. Okay. So no indemnification um when when comparative negligence. Okay. And comparative negligence, I think. I'm saying I think because I can't, I'm pretty sure, is when you're comparing the negligence of the um, person bringing the lawsuit and the person they're suing. And so, like, the um, the plaintiff has like some responsibility, I think. Okay. Defenses to negligence. Um, uh, uh, mm, I'm getting annoyed that I don't think I answered that right. So now I'm going to go back and double check the comparative fault because I want to make sure I actually do know what that means, or comparative negligence. Um, okay, so comparative fault, most jurisdictions have oh no, sorry. No, that's not what I meant. God, this study guide sucks. I'm sorry. I'm not going to say what company I'm using because I don't want to do that because they don't suck. But I'm just very annoyed at like the thing I needed. Like, I just get annoyed when like definitions I need show up later. But anyway, okay. So comparative fault. Um, okay. All right. Um, so I was right. So comparative negligence is when you're comparing the conduct of the plaintiff and the defendant. And so you have some jurisdictions where it's pure comparative negligence, which means even if it was a little bit of the plaintiff's fault, they might be able to still get money or whatever they're trying to get. Um, but majority of comparative jurisdictions use not pure comparative negligence, but they use modified comparative negligence, which means, oh Lord. Okay. Yes, I should just go ahead and write this down. Okay. Comparative negligence, um, pure or modified, and modified means judgment reduced by amount of fault of plaintiff. Well, plaint plaint if plaintiff is at fault, collects less. Maybe that's what I'm trying to say. Is less at fault. If plaintiff is more at fault, then no recovery. When I say recovery, I just mean like collecting money. Give me 1 second. I'm gonna I need to close my window because it's getting a little bit chilly, which is kind of crazy because it's been very, very hot here. I am back. Okay. If they're equal at, well, duh. All right, this is stupid. If equally at fault, plaintiff and pay half. Okay. Let me need to plug my computer in. Give me 1 second. I don't want my squeaky chair to be too loud. Okay. Sorry, give me 1 second. I want to just look at or try to look at something on my YouTube. I'm still figuring all of that out too. Mm. Oh, okay. Sorry if I hurt your ears with that. I didn't mean to. Okay. All right. So if you have multiple defendants, all right, now I need to go back to what I was doing, which was okay. Okay. So now we will start on defenses to negligence. And feel free to let me know in the chat how you found me, or if you have any questions about law school or preparing to be a lawyer. I can tell you a little bit I know. Well, I mean, law school has taught me a lot, so, but still have a lot more to learn. Oh God, I just freaking did this. Okay. So defenses to negligence are contributory fault and assumption of the risk. I do think I remember this from my 1L or my like first year. Okay, so it's contributory fault and assumption of the risk. Now ready, I remember enough contributory fault. It's like how much of the fault was the plaintiff's for whatever happened. And then assumption of the risk is like, did the plaintiff like did the plaintiff take on that risk? Did they know about it and just go ahead and do it anyway? So basically, like, they were well aware of what could happen, and they just went ahead. So a contributory fault occurs when a plaintiff fails to exercise reasonable care for safety and contributes to injury. All right. I guess I'll write that down. Fails, well, plaintiff fails reasonable care. And if you were here earlier, reasonable care came up earlier, and just in general for negligence, the court is going to look at your actions and say, did you act as a reasonable person would under these circumstances, or like with the response with the or did you exercise reasonable care? It's all about the reasonableness of your actions. Now that changes depending on exactly what the like the lawsuit is about, but in general, like that reasonable is like your baseline. Okay, anyway, so contributory fault is when the plaintiff fails reasonable care and contributes to their injury. And that could be physical injury, but it also means like property damage, for like defamation, like injury to your reputation, things like that. Suing for negligent rendering of services, plaintiff's negligent conduct in creating the condition that the defendant has been, oh, no. Oh, I see. Emergency, so, emergency personnel can't sue for, well, actually, that's kind of under assumption of the risk. So what I'm talking about is a note in my study guide. This isn't what it says, but this is what's talking about. Like if you're a firefighter and you have to run into like a really dangerous building to save somebody and you get hurt, you can't go ahead and then sue the person who called 911 for like to pay for your injuries. Like you were there to help them. Like you can't sue them for like causing this thing that you're running into. And that's kind of, I think, lines up with like assumption of the risk. Like that's a risk the firefighter's taking on. The firefighter knows like there's a chance of getting hurt running into that building. Okay. Contributory negligence, the traditional rule. So a lot of times with legal things, of course, there's like the traditional way to think about it, the modern way to think about it, and then like some wacky ways to think about it. And it all just depends on where you're located. So like one state might do things completely differently than another state. So the traditional rule is that if there's any contributory negligence for the plaintiff, then they cannot get any money. So I'm gonna write here, let me bold this. Contributory fault, traditional rule is if plaintiff contributes, then, well, I'll just put cannot recover. And again, recover just means like, because what you're doing is you're trying to make yourself whole. You're trying to fix the injury that was caused. Okay, so you can't recover the amount that you lost or what the value of what you lost. Okay, contributory negligence applies at common law in a handful of states. So examples include plaintiff pedestrians crossing the street against the light. So what that means is an example of like a plaintiff contributing to their injury is if a plaintiff crosses the street when it says don't walk. Then in places where they follow this rule, that means that you can't sue if you got hit because you're partially responsible for getting hit because you walked against the walk sign. And that won't be the case It could be like it could be the case if you were hit by the car in Oklahoma, but you might have been able to sue if you were hit by the car like in Texas. It just depends on geographically like what the law, what the courts in that area do. So, in some places, you can't contribute at all if you, I mean, sorry, you can't collect at all if you contribute to your injury. Okay, I think that's good. A rescuer who takes significant risks when attempting to rescue may also be permitted, but I think that's more like moral benefit, quasi-contract. Okay, sorry, talking a little bit to myself, but that's just because I'm reading my study guide as I'm going. Okay, contributory negligence is not defense to intentional tort, gross negligence, or recklessness. Can't be used in intentional torts. So that's like assault, battery, conversion, or like theft. Can be used intentional torts, gross negligence. Do I really remember what a gross negligence is? I don't, but I'm sure it's going to come up. Or recklessness. Okay. So one defense. What? Okay, it's contributory fault. And we went through the traditional rule. And got it. So last clear chance. So in contributory negligence jurisdictions, a plaintiff may mitigate legal consequences of their negligence by proving that the defendant had the last clear chance to avoid injuring the plaintiff and failed to do so. Okay. Last clear chance doctrine has been abolished. All right, then why do I need to learn it? Helpless plaintiff. A defendant is responsible if they knew or should have known of the plaintiff being in a dangerous situation and could have avoided harming the plaintiff. All right, I don't think I'm going to write this down. This is just a little bit of a judgment call for me. All right, comparative fault. Got it. And this is very annoying because my head is already mixing up contributory faults and comparative fault, but obviously those are different. So, and I think that's something I was doing earlier. I don't think I realized for some reason that they're completely different words, which is kind of silly. But okay, that actually kind of helps me from earlier when I was getting confused. So, all right, contributory fault is when the plaintiff has contributed to their injury. Got it. Okay. Comparative fault, this is what's used by most JX. And remember, JX stands for jurisdictions. It just, it's like so annoyingly long to write out. So comparative fault, there's two basic types of comparative fault. Okay, comparative fault and comparative negligence are the same thing. I need to remember that too. So there are two basic forms of comparative fault, pure fault and modified comparative fault. Okay, so there's pure comparative fault and modified partial comparative fault. Okay. And jurisdictions have adopted pure comparative negligence, contributory, got it. I did just write that down because I just did that. Got it. But I'm going to write it down again. Pure comparative fault, which also is the same thing as pure comparative negligence, means if plaintiff is at all responsible, cannot sue. Well, I'll just say cannot collect. They can sue if they want. but they just won't win. Sorry, I totally got that wrong. That is not true. This is not true. Pure comparative negligence means calculation. Okay, the plaint what am I trying to say? What I'm trying to say is like when the plaintiff has some fault, they don't they they only get what the defendant caused. So like let's say they caused $100 of damage and the plaintiff is responsible for $20 of the damage, they're only gonna get $70 back. Does that make sense what I'm saying? If you're watching, let me know in the chat if that makes sense. Okay, so basically like the amount the plaintiff gets is reduced by their fault. Slash, I think the other way to say that, like, defendant only pays for their part. That's probably the easier way to remember it, I think. The defendant, when the plaintiff is partially responsible, the defendant only pays for their part. Okay. Oh, and the saying always use this test. Always use pure comparative negligence. Okay, so I'll just put default here. And default, like when you think about like default settings, there's some laws that have like default rules, like if this is the rule unless someone changes it. Okay, so there's also modified comparative fault. All right, and that's the one that I just did above. So if you're watching me and you're like, you just did this, you are correct. But I'm not, but this is a good example of how all of these different concepts like link together. Okay, anyway, I think I remember this because this just meant if plaintiff is more at fault, they cannot collect, I think. If plaintiff is less at fault, they get the defendant pays only for defendants well, I can't spell defendants share. Equally at fault plaintiff and defendant pay equal. I feel so dumb to write down. It's like that one just makes sense, right? Okay. Blah 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 blah. Okay, I think I decided I'm not gonna write this down. Okay. Imputed contributory negligence. Gosh. Let me look back over what I have so far. Okay. Joint and several liability. No. I'm going to keep trucking along. And that's another thing too that's just hard with bar prep is there's so much of it. You have to like you kind of just have to keep going to get through it because I still have plenty more to do. Okay. Now we're going to talk about imputed contributory negligence. And that's when another person's fault is imputed to the plaintiff to prevent or limit recovery for that other person's fault. Okay, I don't know what that means, but thankfully they give us an example. If an employee is driving negligently, oh, okay. I see. So the example they gave is like let's say a company has van drivers, like it's a delivery service. Um, if if like the company's UPS and one of the truck drivers gets into an accident and it's partially the truck driver's fault, that means that UPS um won't get will only get the money that the person they crashed into, that for the damage that the person they crashed into caused. So in other words, like if UPS has a truck driver who gets into an accident and they are in a they have contributory negligence applied, that means that UPS is going to not recover like all of the damage that happened to their truck. They're only going to recover what their truck driver did not cause. Okay. Oh, and I went through and explained all of that just to be told that this is, courts do not like using this. Um, and it does not apply to marriage, parenthood, automobile passengers, and automobile owners. Okay. Hmm. I feel like my brain is kind of running into a wall, which actually makes sense because I've been going for like an hour straight. Um, what I might do is I might hop off of here. I think I might take like a half-hour break. And then I might just hop back on. I have a tutoring session later tonight. But yeah, I mean, bar prep is like 6 or 7 hours a day. So I mean, I could literally be streaming for that long. Um, but yeah, my brain hurts. But if this was interesting to watch, feel free to share. Check and come back later, or just make sure you hit the when you hit subscribe, you hit subscribe again, and make sure all notifications are on, so then you know when I go live. Because I might not schedule this next one, but I think I'll come back online like in a half hour or so. But all right, thanks for watching and hanging out with me. This was really good studying for me, actually. I will talk to you guys later. Bye.